Hearing in the appeal of Providence Building Services Limited against Hexagon Housing Association Limited.
Yes, Mr. Lewis.
May it please you, I appear on behalf of the appellant with Nicholas Kaplan, Hexagon Housing Association. My learned friend, Mr. Chenow's King's Counsel, appears on behalf of the respondent, Providence Building Services Limited. My lords, this appeal concerns a point of construction with important consequences for the parties and those who contract under JCT Design and Build Standard Form 2016, yes, and indeed other forms within the JCT suite of contracts that contain materially the same termination provisions. Hexagon's case is that the meaning of clause 8.9.4, when its wording is construed as it must be in its immediate and wider context, is that termination by the contractor of its employment for a repeated specified default under clause 8.9.4 may only be exercised where a right to give a further notice under 8.9.3 to terminate had first accrued but not been exercised. My lords, subject to the court, I intend to structure my submissions as follows. First, the wording of clause 8.9.4 in context. I will focus on three particular factors. First, the immediate context being clause 8.9 as a whole. Second, the contractual context provided by clause 8.4, the employer termination provision. And third, the wider context comprising the genesis of the words used by the draftman in 8.9.4 and 8.4.3 by reference to the predecessor wording in the 1998 form and the amendments made to that wording in 2005 that carry through to the 2016 form and indeed through to the 2024 version of the form. Second, my lord, I'll deal with the commercial consequences of the rival interpretations as part of the iterative exercise of interpretation. In short, we submit that Hexagon's interpretation produces materially more commercially sensible results than Providence's interpretation, which when properly analysed is highly problematic. My learned friend Mr. Kaplan, I hope if time permits, will deal with the JCT guide. My lord, turning first then to clause 8.9.4, the extract of that clause as amended is at page 351 of the core bundle. The approach of the Court of Appeal and indeed Providence was to start the unitary exercise of interpretation with the words that are to be interpreted, and in particular what have been described by the Court of Appeal, paragraph 29 of the judgment, as the conditional words if the contractor for any reason does not give. And we don't submit, my lords, that that is wrong in principle, but we do take issue with how Providence seeks to frame the principal question, largely adopted by the Court of Appeal, which is whether Hexagon can demonstrate that there is anything within the wider context that qualifies the meaning of the conditional words and the right to terminate for repeated default. We do not agree that that is the correct way to frame the question, because firstly it assumes what it seeks to prove in terms of the meaning of the conditional words, namely it assumes that they mean only a factual state of affairs, no notice having been given. Therefore, we submit that the correct way to frame the question is what do the conditional words mean in the context in which they have been used. My lords, this should be uncontroversial, and I needn't take you to the authority, but as Lord Neuberger observed in Sigma Finance, to consider what words could mean in the abstract is not normally a helpful exercise. Therefore, we submit it is critical to construe the words in context, and in particular the immediate contractual context in which they appear, namely clause 8.9 as a whole.
I mean, it was a slightly unusual way to proceed, was it not, for the Court of Appeal, to say in paragraph 29 that you must start with the words in isolation, and then to say, but it's necessary and vital to read them in context.
Absolutely, we agree.
Didn't Lord Newberger say you have to start somewhere?
He did. You have to start somewhere. And that's why we don't say that it's wrong in principle to start with the words themselves. But the way in which the Court of Appeal articulated the question, which is the way that Providence articulates the question, is, as my Lord Burrows just indicated, that one assumes that the words are unconditional in their ambit, and then one has to look at the wider context in order to qualify those words. And we submit that that is not the correct starting position, and it places an unnecessary and incorrect onus on Hexagon. We submit there are three relevant contextual factors which result in Hexagon's interpretation being preferred. The first is the structure of Clause 8.9, and in particular, the express reference in Clause 8.9.4 to Clause 8.9.3, and the resulting connection between those two clauses, and why, in fact, properly analysed, Providence's construction of Clause 8.9.4, as accepted by the Court of Appeal, results in a disconnect between those two subclauses. The second relevant contextual factor and issue is the misplaced emphasis we respectfully submit on the apparent similarities between Clause 8.9.4 and the equivalent employer termination provision in 8.4.3, compounded by the failure to properly acknowledge the material difference between those two clauses. And the third contextual factor is the genesis of the words that fall to be construed by reference to the predecessor forms. My Lord, dealing then with the link or connection, as I put it, between subclauses 8.9.3 and 8.9.4, the relevant clauses are extracted at page 351 of the core hearing bundle. The Court of Appeal accepted, we respectfully submit correctly, at paragraph 31 of its judgment, that Clause 8.9 operates as a sequence of events that may lead to termination by the contractor of its employment. And we describe the structure or the clause at paragraph 69 of our written case, page 42, as a cascading series of linked provisions. So we're dealing with the structure. Clause 8.9.1 is engaged upon a prescribed default arising. If it arises, a notice specifying that default can be given under that clause, 8.9.1. Clause 8.9.3 is engaged only, and I emphasize the word only, in the event that a notice of specified default has been given pursuant to Clause 8.9.1 and the default continues for 28 days from receipt of the 8.9.1 notice. It's 14 days in the unamended version of the form. If Clause 8.9.3 is engaged because a specified default has not ended within the prescribed period, only then may the contractor give the further notice under Clause 8.9.3, subject to doing so within 21 days of the expiry of the 28-day period. Importantly, we submit, if a specified default has not continued for 28 days, there can be no question of Clause 8.9.3 being engaged, and therefore no question of the further notice being given under Clause 8.9.3. So, my Lords, we say the subclauses of Clause 8.9 may be seen as a series of gateways through the operation of which notices may be given and termination may be effected. The contractor does not step through the gateway of Clause 8.9.3 unless there is a specified default, and that default has continued for 28 days following the service of a notice under Clause 8.9.1. If a default has continued for 28 days, Clause 8.9.3 is engaged. In that case, we submit the gateway is opened and a further notice terminating the contractor's employment may or may not be given by the contractor under that clause, the contractor having a choice whether or not to give the further notice once the gateway is opened. And my lords, if the further notice is given, then the contractor terminates its employment under the contract, and in that circumstance, there is no question of clause 8.9.4 being engaged, nor is there any question of a specified default being repeated because the contractor's employment has been terminated. But if the further notice is not given, the contractor's employment continues and there remains the potential for a specified default to be repeated. And if it is repeated, then clause 8.9.4 is engaged. Now, on Providence's case, and this is important to note, my lords, clause 8.9.4 may be engaged in circumstances where 8.9.3 has never been. In other words, it is the mere repetition of a specified default that is sufficient to engage and trigger the entitlement to terminate under clause 8.9.4. Once that important point is appreciated, on Providence's interpretation, the reference in clause 8.9.4 to clause 8.9.3 and the contractor not giving the further notice referred to in that clause is not only superfluous, but also particularly inept to give effect to the supposed intention that clause 8.9.4 provides a right of termination independent of any right under clause 8.9.3 having arisen. And the reason why it is particularly inept is that clause 8.9 as a whole would simply and clearly operate as Providence contends had the words, if the contractor for any reason does not give the further notice referred to in clause 8.9.3 not been included at all.
So you just go straight to 8.9.4 small 1.
With the clause simply referring to that, yes. The clause need only say the question of repetition. And the logical conclusion we submit of Providence's interpretation is that the reference to clause 8.9.3 in clause 8.9.4 serves no purpose other than to state the obvious, because if a notice under clause 8.9.3 is given, the contractor's employment is terminated, and clause 8.9.4 will not be engaged in any event. And my lords, without wishing to overplay the gateway analogy, the contractor can only be at the gates of clause 8.9.4 if the contractor's employment subsists, there having been no termination under clause 8.9.3. Conversely to Providence's interpretation, we submit that Hexagon's interpretation respects and is consistent with the structure of the clause, but also gives purpose to the reference back to clause 8.9.3 in 8.9.4. On Hexagon's interpretation, the reference in clause 8.9.4 back to 8.9.3 and the contractor not giving the further notice under that clause serves the purpose of connecting the two subclauses and recognises that the accrual of but non-exercise of a right to give the further notice under clause 8.9.3 is a condition of engaging 8.9.4. My lords, turning to the Court of Appeal and Providence's emphasis on the words for any reason in clause 8.9.4, the Court of Appeal placed, as Providence places, emphasis on the words for any reason in 8.9.4, deciding that those words reinforced the width of the conditional words does not give in order to capture a case where the reason no notice was given under 8.9.3 included the case where there was no accrued right to give it. And my lord, that point is made throughout the judgment at paragraphs 29, 31 and 44. We set out Hexagon's case on how those words fall to be construed in paragraphs 50 to 55 of our written case, but in essence, we submit the words for any reason are, when read in their immediate context, consistent with the structure of Clause 8.9, because they reflect or recognise the choice that the contractor has once a right has accrued to give a notice under Clause 8.9.3 as to whether or not to give the further notice under that clause, it not being mandatory to issue a notice once a right accrues. And conversely, Providence's reasoning suggests that a function of the words is to reinforce or clarify that the conditional wording in 8.9.4 is broad enough to capture a case where the reason no notice is given is because there was no right to give it in the first place. And there are three difficulties with that contention we submit. First, the wording on Providence's construction is superfluous, because had the right accrued and the notice under 8.9.3 been given, the contract would have been terminated with no scope for a repetition of a default. Second, and moreover, the wording is not merely superfluous, the wording is particularly inept or maladroit, because it introduces the very ambiguity that the words are said to attempt to resolve. And the third point I make in relation to Providence's contention is it is possible, as the Court of Appeal accepted, to test that suggested intention or interpretation against the equivalent employer termination provision in Clause 8.4 as part of the immediate contractual context. And it's that I turn to as my second factor relating to context. My Lord, the relevant clause, again, is extracted.
So in essence, as I understand it, your submission is that where an employer has always cured in the past by paying within 28 days, you never can get to 894.
That is the effect.
Yeah.
Now, the point that is made against me in relation to that is that creates a mischief, and I'll deal with that mischief when I come to the commercial consequences of the rival interpretations. Just looking at Clause 8.4, the Court of Appeal dealt with 8.4 at paragraphs 32 to 33 of its judgment, concluding that comparing the two subclauses, 8.9 and 8.4, there was, as the Court of Appeal put it, an important congruence of structure, and the conditional wording does not give, and therefore the conditional words does not give must carry the same meaning in both clauses. We submit that the meaning of the conditional words in Clause 8.4.3 are different, because in contrast to 8.9.3, they continue by expressly referring to the case where a specified default has ended, and that being a reason for not giving the further notice under Clause 8.4.2, which is the equivalent to Clause 8.9.3 in the contractor termination provisions. And the Court of Appeal held, paragraph 33, that the words "for any reason" were at least as broad as the words "whether as a result of the ending of any specified default or otherwise," and therefore felt to be interpreted in the same way. And with respect, we submit that that suffers from a circularity of reasoning, because it assumes what it seeks to prove. The wording is only at least as broad if it is accepted that the words "for any reason" in 8.9.4 captures the case of no right to give the further notice having arisen, but that being the very question in issue. And really, my lords, it comes down to this. The logical conclusion of the Court of Appeal's reasoning and Providence's case is that the draftsman, inexplicably, because it has never been explained by Providence, nor has any explanation even been offered, chose different wording in equivalent subclauses within the same clause in order to give effect to the same intention. We submit that that is inherently unlikely, but furthermore, it doesn't sit easily with two principles of contractual interpretation which I would expect to be uncontroversial. First, in the context of the interpretation of a standard form, the focus more than ever should be on the words actually used. See the Lemaiza case at page 925 of the bundle, which is at paragraph 19 of the judgment, where Sir Geoffrey Voss, sitting as a Chancellor of the High Court in the Court of Appeal, as he then was, cited with approval the decision of the Court of Appeal in the State of Netherlands and Deutsche Bank. My Lords, perhaps not necessary at the time available.
Before doing that, could we just go back to the page 350, paragraph 8.4.2? One has a further notice referred to. And there's no accrued right to give that further notice until the expiry of a 14-day period.
Yeah.
And is in 8.4.3 the further notice such a notice? That is a notice which could be given at the expiry, only at the expiry of the 14-day period.
Yes, in 8.4.3, the further notice being referred to in clause 8.4.2 is the notice that can be given and only be given in circumstances where the default has not been cured within 14
days. Okay. And does that then inform the wording whether as a result of the ending of any specified default? Because you could have an ending of a specified default before the end of the 14-day period, in which case you couldn't give the further notice.
Yes, if the specified default is cured within the 14-day period, you couldn't give the further notice.
But the Court of Appeal, as I understand it, said that the specified default, sorry, the curing of that, ending of any specified default could occur before or after the end of the 14-day period. So there's, on your argument, there's a symmetry between these two clauses.
Not yet.
At the moment, I don't understand how a further notice is defined in the further notice is defined in one sense in clause 8.4 and in another sense in clause 8.9. You say in 8.9 there is no accrued right to give it, and in 8.4 you say there is an accrued right to give it.
In 8.4.2,
yes,
if the contractor continues to specify default for 14 days from receipt of the notice, the employer may give the further notice, which is the equivalent provision to clause 8.4.3 in the 8.9.3 in the contractor termination. If the employer does not give the further notice referred to in 8.4.2, whether as a result of the ending of any specified default or otherwise, the contractor repeats a specified default, then a further notice can be given. And we submit that the reference there is to the ability to, in the event that the employer doesn't give the further notice referred to in that clause within the relevant period, and the contractor repeats a specified default, then the employer may, by notice, the contractor terminate the employment.
Could I just ask you at 8.4.1, where the trigger is that the employer repeats a specified, 8.9.1 on page 295, the trigger is the employer repeating a specified default. one assumes that to understand what a specified default means, one looks back to 8.9.1.
My Lord, yes.
I'm sorry?
My Lord, yes.
But that doesn't just mean one of the defaults described in point 1, point 2, or point 3. It means one of those which is made the subject of a default of a specification notice.
Yes.
My question is, in order to trigger 8.9.4, does the contractor have to specify a later repetition default as a specified default at when or just before he gives notice of termination? Or is, I mean, just take, for example, a late payment. A late payment doesn't become a specified default unless it's specified in a notice. What about a repeated late payment? Does that also have to be specified in a notice, or is it automatically a specified default because it just looks like the previous one?
That was certainly the approach of the Court of Appeal, and that's my understanding of how the clause operates. One doesn't need to provide another notice specifying the repetition of the default.
But it does need that.
It does.
Yes. Yeah.
But it what, sorry? I missed that.
The contractor doesn't need
doesn't.
to serve a further notice specifying.
Doesn't need
Doesn't
a further notice.
No.
But if you, I don't know if this matters really, but in 8.9.1, the contractor has to give, or may give to the employer a notice specifying the default. Well, presumably that's a default in paying the interim account due by the 19th of June 2025.
Yes.
Well, it's not that default which is going to be repeated.
No.
So doesn't there have to be a notice specifying a failure to pay the interim account, the subsequent interim account, by the 20th of November 2025?
Well, the Court of Appeal, I think, in their judgment, proceeded on the basis that the repeated default didn't need to be an identical default to the...
This is paragraph 28.
I mean, it couldn't be, could it? It couldn't be an identical.
It could, other than the broadest terms.
Other than the nature, the
nature of it.
Well, we know that because it's a late pay. Anyway, it probably, does it matter, the resolution of this particular issue, does it matter to the issue before us?
We submit it doesn't, because the principal question remains whether or not the right to give the further notice under 8.9.3 is accrued.
Yes.
And if it was a breach of the CDM regulations, one would think that without some specification of the breach, the employer would think, well, okay, I've suddenly had the contract terminated. What breach of the CDM regulations was it that I committed? There seems to be some common sense in having to specify what the breach is.
My Lord, I can see that in practical terms it would give rise to difficulties, but the clause itself doesn't prescribe that a further notice is given to specify the repeated default.
Well, depending on what a specified default means in point 4.1, yes. Okay.
My Lords, I was just going to deal briefly with the two points of contractual interpretation which I wouldn't have thought were controversial. The first is that in the interpretation of a standard form, the focus more than ever should be on the words actually used. And therefore we submit that as Geoffrey Voss said, as he then was, at page 926 of the bundle, paragraph 19.3, the words used by the draftsman should be taken to have been selected after considerable thought. And therefore we submit that the difference in wording between the employer termination provision and the contractor termination provision cannot and should not be explained away as of no significance or the result of inconsistent drafting or otherwise essentially ignored. The second principle is the presumption of the uniformity of expression. And this was essentially acknowledged by the Court of Appeal, at least implicitly at paragraph 33 of their judgment, but actually against Hexagon. It is a reasonable presumption, we submit, that a draftsman aims at uniformity, and particularly so in a standard form, and therefore uses the same words to express the same thing or concept, so that where the draftsman uses different words, the presumption is that he means a different thing or concept. And my lords, support for that proposition, if support was needed, is found in the dicta of Lord Justice Bingham, as he then was, in John Jarvis and Rockdale Housing Association, citing with approval observations of Lord Justice Diplock, as he then was. And my lord, the relevant, for your note, the relevant page of the bundle is at 872. And we submit is therefore of significance that the draftsman has used different wording in 8.4.3 to that used in 8.9.4, and in particular, the draftsman has chosen to refer to the ending of a specified default in 8.4.3 as a reason for not giving the notice, but has not done so in 8.9.4. And that is all the more significant, we submit, given the genesis of the words does not give the further notice as used in both 8.9.4 and 8.4.3. And that, my lords, is my third factor in relation to context. Now, it is right to say that an exercise in considering earlier versions of a standard form as a guide to construction has been met with a lack of judicial enthusiasm and words of caution. But neither party in this case, as we understand it, submit that the previous versions of the standard form are inadmissible. And there is, in fact, no authority that supports an absolute bar. To the contrary...
Lord Justice Morbick restricted it pretty heavily, didn't he?
He gave examples of where it would be appropriate.
I mean, it wouldn't normally be appropriate, would it? I mean, the problem is you've got contracting parties in 2025, a building company and an employer. Are they really expected to trawl through the 1998 standard form and the commentaries on it in order to try and understand the words on the page of the now the 2024 standard form?
Well, my lords, let me deal with that point. Dealing first with the lack of judicial enthusiasm, Polestar Maritime and YHM Shipping, which is at page 989 of the bundle. The facts are immaterial, but it concerned the construction of a standard sail contract on an amended Norwegian sail form. The Court of Appeal was invited in argument. It's not explained why in the judgment, but it was invited in argument to look at a previous version of that form and commentary as an aid to construction, which it declined on the facts. But in terms of principle, Lord Justice Akins indicated at paragraph 30 that in appropriate cases, it may well be necessary in order to understand the meaning of the successor form. And in order to address the point that was put to me, we submit that in an appropriate case, a predecessor form and its evolution may properly form part of the factual matrix against which a successor form falls to be construed. And the starting point is that in the case of a standard formal clause, it is not context specific, and evidence of the factual background to the contract itself has much more limited role to play, if any role, and instead the focus should be on the words the draftsman has used, with a recognition that the words have been used by the draftsman, have been selected after considerable thought and continuing user review, as well as the knowledge of the market.
I mean, that's all true, but they are selected with considerable thought in order to be used by building companies and employers up and down the land for contracts large and small.
My lord, yes. So one isn't necessarily concerned when one is looking at the meaning of a clause within a standard form. One is not seeking to identify, objectively understood, the intention of the parties to the contract as to what that clause means, but rather what the draftsman objectively intended the clause to mean.
Is there authority for that?
Well, my lord, there are...
You're saying it's not the objective intention of the parties, it's the intention of the draftsman in a standard form contract?
Well, in order to determine the meaning of an ambiguous clause within a standard form contract, the exercise is one of looking at what the draftsman of the clause intended as opposed to the parties themselves.
But, I mean, Lord Justice Aiken refers to an appropriate case, but what is an appropriate case?
Well,
does it mean any case in which there's an issue as to the proper interpretation of the standard form?
Well, Lord Justice Aiken gave certain non-exhaustive examples of where it may be appropriate or not. We submit that this case is an appropriate case for the reasons that I'll give.
Sorry, can I just be absolutely clear? You're saying there is authority to the effect that we're not looking at the objective intention of the party. Well, we're looking at the draftsman's intention. Is this the authorities you're giving us?
Well, my lord, if one looks, as an example, at Lord Hoffman's speech in Beaufort Developments and Gilbert Ash.
Yeah.
Do you have a page number for that?
Which is at...
626.
Just bear with me.
You previously referred us to Sir Geoffrey Voss saying that in standard form contracts you've got to be very, perhaps place more weight on the words used rather than the context. I think that's what you were telling us. But does he anywhere in that judgment say anything about it not being the objective intention of the parties?
He doesn't. He doesn't say that in that case. It's page 626 is the...
626 is the
Beaufort Developments and Gilbert Ash case.
Is the case, but where is the pithy passage?
Well, it's 274D of that case. 274
of the law report numbering. So that's at 634.
So this concerned the correct construction of an arbitration clause within a standard form JCT contract. The relevant paragraph is at 274D of Lord Hoffman's speech. Beginning with, it is also important to have regard to the course of earlier judicial authority and practice on the construction of similar contracts. The evolution of standard forms is often the result of an interaction between the draftsman and the courts, and the efforts of the draftsman cannot be properly understood without reference to the meaning which the judges have given to the language used by his predecessors. And my lords, develops...
Well, he's not quite saying it's not the objective intention of the parties.
But what this is some support for is that when the court is concerned with trying to construe a standard form, it's involved, or it's engaged with in inverted commas, with a dialogue with the drafters of the form, as opposed to looking at what the objective intention of the particular parties to the contract.
Right. I wonder how that works when they've actually made amendments to the contract.
Yeah, as they almost always do.
Well, I'm not saying, my lord, that the exercise is exclusively looking at the draftsman's intention. But in a case of a standard form, which is not context specific, in order to determine what the meaning of the clause was, one can't simply look at, in my submission, the objective intention of the parties. One has to also consider the objective intention of the draftsman, and that is why it's appropriate in certain cases to look at how a form evolved by reference to previous authority. One is looking there at the understanding of the draftsman of the standard form dealing with previous authority.
But that's what Lord Hoffman refers to there is one of the examples.
It is.
Possibly the principal example that Lord Justice Morbick gave for when it is appropriate to look at the prior form.
It is, and the only reason I've referred your lordships to this authority in response to your question is because it demonstrates that it is appropriate, ignoring the circumstances for a moment, it is appropriate in the right circumstances to look at the draftsman's intention as opposed to merely the parties. And why we submit, my lords, that in this case it is relevant, not determinative, but relevant to look at the evolution of the form, is because when changes have been made by a draftsman to an existing form, that may support an inference that the intention is to change the meaning of the clauses that have been changed. A fortiori, where the changes that have been made are different to previously identical or materially identical clauses. My lord, just then moving, if I may, because I want to cover also the commerciality issues, but if I can deal briefly then with the 1998 form. Now, the 1998 form was the predecessor, in terms of its wording, to the 2016, to the 2005 form. The 1998 form was changed. Its wording was changed in 2005. Now, we submit the draftsman of the 2005 form, that form, its wording continuing through to 2016 and beyond. The draftsman of the 2005 form should be taken to have had knowledge of the 1998 form and its relevant clauses, the wording of which he was tasked with changing, and in fact did change. My lords, the 1998 form is at page 387 of your bundle, the relevant...
Page what?
387.
Thank you.
The relevant extracts of it. The employer termination provision is at 27.2.1, and it prescribes the defaults. Clause 27.2.2 provides that if a specified default continues for 14 days from the date of notice, then the employer may terminate by the giving of a further notice. Now, importantly, we submit, clause 27.2.3 is expressed disjunctively. And importantly, we submit the words does not give the further notice referred to in clause 27.2.2 are not addressing the event where the notice cannot be given because of the ending of a specified default. That is addressed separately and disjunctively within the clause. And the same analysis applies to the contractor termination provision, which was in identical form within the identical wording, materially identical wording in the 1998 form. And therefore...
so where do we find that, sorry?
I'm sorry, my lord. The contractor termination provision is at page 391.
391, thank you.
Yeah. So again, you have clause 28.2.3, which is the predecessor of clause 8.9.3, and clause 28.2.4, which is the predecessor of clause 8.9.4, it's expressed disjunctively. And the words does not give the further notice referred to in clause 28.2.3 are not addressing the event we submit, where the notice cannot be given because of the ending of a specified default, that being addressed separately and disjunctively. And therefore, in the 1998 form, the words does not give the further notice in clause 28.2.3, because of the context in which those words were used, did not extend to the situation where the reason for the notice not being given was the ending of the specified default. Now, it's common ground that in 2005 the draftsman amended that wording of both clauses 27 and 28, and the amended wording is that found in the 2005 form, continuing through to the 2016 form and indeed to the 2024 form. And then just briefly, my lords, turning back then to clause 8.9.4 in the instant 2016 form, which is at 351. The following is important to note, we submit. The draftsman has omitted the words that functioned in the 1998 form to cover the scenario where the right to give the notice had not arisen because of the ending of a specified default. Now, that omission in that clause is to be contrasted with clause 8.4.3 in the 2016 form, page 350, where the draftsman has chosen to preserve and use those words, thereby expressly extending or changing the ambit of the words does not give, in order to cover the scenario of no notice having been given because of the ending of a specified default. And the logical conclusion of Providence's case is that the draftsman in 2005 is engaged in an exercise of amending both clauses from the 1998 form, intends them to be, as they were previously, the mirror of one another, yet inexplicably amends them differently. Furthermore, he omits from the contractor termination clause the very wording that he uses to preserve in 843 to capture the event of no right having arisen to give the notice under 8.9.3 because of the ending of a specified default. And we submit, my lords, that that is significant and entitles an inference to be drawn that the draftsman intended, or the objectively construed, the meaning of each of the clauses is different. My lord, if I can briefly turn to the commercial sense of the competing interpretations, and we deal with it in some detail in our written case, but I'll just seek to highlight some of the important points and to address the point that was put to me earlier. Just dealing first with uncontroversial principle, that if there are two possible interpretations of a commercial contract, the court is entitled, as part of the unitary exercise, to favour the one that makes more commercial sense. And support for that proposition in Wood and Capita, per Lord Hodge, paragraphs 11 and 12 of his speech, at page 1386, page 1390 of your bundle. Now, the Court of Appeal considered that both interpretations could be justified commercially. Hexagon's overriding submission is that its interpretation makes materially more commercial sense than Providence's, and that Providence's interpretation is likely to produce results which are difficult to justify commercially. I'll deal with the question that was put to me head-on, the possible mischief, which is the apparent mischief of a malevolent employer paying just before the expiry of the cure period within each cycle.
The 27-day employer.
And thereby preventing the contractor from being able to terminate under 8.9.3.
Also using that as a technique to get rid of a contractor by making him go into insolvency.
Well, I'll deal with both points. The first is that hypothetical example is a particularly extreme example. I'm not saying it's an impossible scenario, but it's a particularly extreme example of an employer behaving badly. In circumstances where, on the hypothesis, the employer is at each cycle waiting until just before the end of the cure period to pay in order to prevent an 8.9.3 notice being served, we submit that that would give rise to a strong argument for repudiatory breach.
But I thought that is what was happening here. Am I wrong?
On the facts, we disagree. Hexagon disagrees with that entirely. There were inadvertent late payments that were rectified, in most cases, speedily, and the specified default was given within, I forget the particular month, and then the repetition of that breach was about 6 months later. So we disagree that is...
We're up to payment notice 27. How about the previous 26 payment notices? Were they all paid on time?
They were not all paid on time.
Were any of them paid on time?
Yes. My Lords, if I can just deal with the point about, if you want to look at the facts of this particular case briefly, but I think it is important just to underline this point, that the parties have been through an adjudication where no significant criticism was found of Hexagon's intentions or conduct. And similarly, I think I'm right to say that similar observations were given more recently on an application to stay the enforcement of the adjudicator's decision by the judge sitting as a Deputy High Court judge. But just dealing with the mischief, an employer that was effectively evincing an intention not to comply properly with its contractual obligations, i.e. paying by the final date for payment and continuously paying late, that would give rise to a strong argument, we submit, for a repudiatory breach, which is in fact an allegation that has been levied against Hexagon in this case.
And which I think remains unresolved, doesn't it?
And it remains unresolved. The second point, so the contractor would have an ability to determine the contract. The other significant remedy that the contractor would have in that situation is the right to suspend. And that requires only 7 days notice to be given. And notice will be given on the day of the hypothetical default. Now, in our submission, the right to suspend, which was a right introduced by the Housing Grants Act, and as my Lord Briggs indicated in Bresco, was part of a powerful a powerful range of remedies in order to deal with cash flow issues.
Well, I was looking at the range rather than this one in particular, I think.
You were looking at all of the remedies introduced by the Housing Grants Act. They obviously included adjudication, and a powerful remedy that previously didn't exist was the right to suspend.
There is legislation nowadays to address the problem of late. I mean, it's endemic in business. The late payment of commercial debts. Is use made of that in the construction industry?
Yes, I mean that's often a remedy that is used or relied upon by parties. So you have a range of remedies. The importance of suspension is it's a remedy that can be activated quickly. It represents, of and in itself, a powerful incentive to the employer to pay on time, because no employer wants to face a project that's stalled by reason of a suspension. Furthermore, the right of suspension and the costs that arise from it in the event that it's been exercised in the event that it's been exercised, under this contract, the contractor is entitled to be paid those costs by the employer. So the scenario, and this is the mischief that Providence highlights in its submission, we submit is unlikely to arise in practice, and if it does arise, is capable of being resolved.
Is there a contractual right to interest on late payments under the contract entered into between the parties?
I think there is, yes. So the mischief that's presented is unlikely to arise in practice and is one that's capable of being resolved. A much more significant, if I can end on this because of time, a much more significant mischief is that arises on Providence's interpretation, because it allows a contractor to terminate with relative ease upon the repetition of a specified default in circumstances where the first default was cured within the cure period and immediately upon the second default, with all of the very significant consequences that flow from that. And we submit that that is a very significant mischief. And if I can end on this point, the real mischief we submit that arises from Providence's interpretation is that in most cases, a right of termination under Clause 8.9 is more likely to be exploited by a contractor seeking to extricate itself from a contract or to renegotiate such a contract for reasons other than addressing short-term cash flow issues caused by late payment. And that is because of the other remedies that a contractor has in order to resolve late payment, in particular the right to suspend. And we submit it is unsatisfactory and highly problematic for a standard form construction contract in such wide use to allow for termination with such relative ease, purportedly to address late payment, but which in reality, and in most cases, will be exploited to address other factors that are not grounds for termination, such as an unprofitable construction contract. We submit that that is unlikely to be the intention of the draftsman without the clearest of words. Those words existed in 1998 and before 2005, and they don't exist now for the reasons that I've submitted. My Lords, unless I can assist you any further, I was going to pass to Mr. Kaplan very briefly, if I may. I know that cuts into
yes,
time.
yes, certainly. You're eating into your reply time.
I know I am.
But so be it. Yes, Mr. Kaplan.
My Lords, good morning. I'm going to address the Court very briefly on a short point that arises about the guidance notes that accompany the 2005 form that was first introduced the current wording. Providence relies on the 2005 guide to make the following submission. In essence, it says that if Hexagon is right, that in 2005 the draftsman changed how the contractor termination provisions operated from how they did in 1998, it is surprising that the guide makes no mention of that, and on that basis it asks the Court to draw an inference that no such change was made. It will be my submission that on a proper analysis of the 2005 guide, it does not provide any support for the inference that Providence asks the Court to draw. My Lords, the guidance note itself can be found at from page 403 of the bundle.
403.
403.
Thank you.
That's the cover page. The changes themselves from the 1998 form are then addressed at part 1 of the guide, which starts at page 407. My Lords, if I could ask you to turn to that.
Yeah.
You will see that the analysis of the changes, or the description of the changes, is split into two sections. The first, paragraph 11, under the heading Content, sets out the principal changes in the substantive changes to the content of the clause, or the clauses. And then over the page at 408, under the heading Structure, the guide goes on to outline how the structure of the provisions have changed since 1998. In its written case, Providence relies in particular on paragraph 14. My lords, you will see that lists each of the sections of the contract and has a heading, section 8, which is marked for your attention. That states the termination section is based on the clauses in the 1998 form, but in considerably abbreviated form. Now, it is uncontroversial between the parties that as a matter of structure, the termination provisions were considerably abbreviated between 1998 and 2005. The point that is controversial is the inference that Providence seeks to draw that the only change that was made was to abbreviate the wording and nothing more. We say that that inference is unsound. We say it's unsound for two reasons. First, when you look at paragraph 14 in context, all that paragraph is seeking to do is describe changes that were made to structure as opposed to content. The second reason, and I took your lordships earlier to the heading Content, paragraph 11 dealing with substantive changes in content, my lords, you will note that that is composed of 9 subparagraphs in Roman numerals. The last of those, Roman numeral 9, just at the top of page 408, lists the termination section, section 8, as among those whose substantive content has changed. My lords, those are all my submissions.
Thank you, thank you, Mr. Kaplan, and for being so succinct. Yes, Mr. Channels.
May it please you, my lord. Whilst the court has it open, can I deal briefly with the 2005 guide to save a little time later? The points to which I draw the court's attention within this document are at paragraph 406, page 406 of the bundle, paragraph 1. The guide says in terms that the purpose of this document is to give a brief overview of the new form, including its main features and points of difference from the JCT standard form of building contract 98. So that's the purpose of the document, para 1. Over the page at 407, paragraph 9, the JCT's intention is stated to be that the content should, as far as possible, be familiar to users of the 98 form. Certain points have been clarified, but there has been no material alteration in risk allocation, and many of the 98 procedures have been retained. Over at 408, my lords. I'd rather use both. No, not at all, thank you. My lords, at paragraph 14, there's the explanation that my learned friend took you to a moment ago, explaining that the termination section has been abbreviated. And then if one goes on, please, to page 421, you will find the section dealing with the termination provisions. I'd invite your attention in particular to paragraph 121, where the right to terminate arises by virtue of default by either party. There is a requirement for notice. And I'd ask the court to note that paragraph, and two things come from this, fundamentally. First of all, both in this guide and in every iteration of the guide going forward, the employer and contractor termination rights are explained as being the same. In other words, these guides all proceed on the basis that clause 8.4 and clause 8.9 operate in the same way, which is directly contrary to the case that's been urged upon you this morning.
Do we know if either party to this contract ever saw this document?
My Lord, we don't.
No. It's been treated really as if it were analogous to legislation. And this is a sort of explanatory memorandum accompanying the Act.
Well, can I make 2 or 3 sorts of points in response briefly whilst we're here? First of all, in the Seadrill and Gazprom case, and if we have time, we'll have a look at the passage. Well, Justice Moore-Bick said there were certain circumstances in which it might be appropriate to have regard to predecessor versions of the form. One of those was where the court could have some confidence as to the reasons for the change in wording as between the standard forms. We say that here the court can be confident that the draftsman did not intend to introduce the fundamental changes between the termination provisions on the one hand of the employer and on the other of the contractor, and nor did the draftsman have the intention to fundamentally change the effect of these provisions as between the 98 and 2005 form. So we say that in terms of the way in which we use the change in this guide, that falls within the rubric of the passage in Seadrill. In terms of my Lord's question as to whether the parties had this in mind, there's no evidence of that. That's a point that's made, I think, by Lord Justice Moore-Bick in the Seadrill case. But of course, what the court is concerned with is the material that was reasonably available to the parties. And in a case such as this, where in a widely used standard form, there are cases on the history, the effect of the previous version of the standard form is well known. Anyone who was concerned with how these rights operate would read those cases and compare the competing forms of words. This material, in my respectful submission, falls within the material that was reasonably available to the parties. I distance myself entirely from any suggestion that one's concerned with the draftsman's intention as opposed to that of the parties. But that's the point on the guidance. In contrast, we respectfully submit that the exercise that the appellant asks you to perform in terms of comparing the wording of the 2 forms and draw an inference as to what the draftsman meant, which is not only contrary to his published guidance, which you might think is a safer guide to what he meant, but that is exactly the sort of exercise that the court in Seadrill counselled against.
And I think you showed us the 2005 guide just then.
I did.
Are the same statements made in the 2016 guide?
My Lord, yes, they very substantially are.
Because, I mean, that, after all, is the guide to the standard form being used in this case.
Indeed, my Lord. If you go, so the guide itself is in the bundle at page 433. Now, it doesn't set out, it's obviously not setting out the differences between the 1998 form and the 2016 form, because that's already happened. But it does deal with the termination provisions. That section starts at page 453. And the key paragraph is paragraph 150, which you'll find at page 454 of the bundle, and which again treats the way in which clause 8.4.3 and clause 8.9.4 operate as being the same.
Sorry, which paragraph?
My Lord, paragraph 150.
Thank you.
So, my Lords, having...
It treats it as a symmetrical provision for both sides.
Exactly right, my Lord. Which is, as the Court of Appeal treated the provision, and that is the basis upon which, and I think this was maintained, although I was not entirely sure, but that is very much the basis. The basis on which this appeal is promoted is that these provisions operate in precisely the opposite way to one another. And if one wants to understand why the Court of Appeal thought that the provisions operated in much the same way, and picking up my Lord Stephen's point about the reference to the 14 days, the answer to that is that as we'll see when we look at it in a moment, Clause 8.4.3 doesn't draw a distinction between ending the specified default within the 14-day period and ending the specified default beyond the 14-day period. If you wanted to achieve that result, you'd again be reading words into what is otherwise a clear provision, which we say is not the proper approach.
But I just had difficulty because you had, in order to have a notice under 8.4.2, you have to have a period of 14 days has to expire. And that then, if the 14 days expires without the contractor remedying, ending the specified default, you can then serve the further notice. It's only when you can do that, when the contractor has failed to end the specified default, that you can remedy it. And 8.4.3 then refers to the further notice. That is the further notice, which can only accrue in circumstances in which the specified default was not remedied within 14 days.
My Lord, the notice that's being referred to in 8.4.3 is the further notice in 8.4.2, which yes, you only have a right to serve if the contractor does not remedy the default within the 14-day period. That's right. That's right. But in making clear that one of the reasons why the employer might not have given the further notice referred to in 8.4.2 is the ending of any specified default, it is common ground in this court that that ending of the specified default could be either before the 14-day period expires or after.
At the moment, I don't follow that. Anyway.
My Lord,
the only occasion on which you can serve the further notice is if there has been no ending of the specified default. And you have a window of opportunity then after the 14 days has expired in which you can serve the further notice. And you may decline to serve it because the specified default has been rectified during that period.
Yes, but my Lord, the qualification that my Lord, in fact, puts within 8.4.3 doesn't appear in the words. And in fact, it's as I say, it's common ground in this court.
Well, it may be common ground, but it doesn't bind us if we don't agree with it.
I appreciate that. I just wanted to make that perfectly clear. But the reason why it's common ground and why the Court of Appeal held as they held is because the words used as a result of the ending of any specified default or otherwise comprehend both the ending of the specified default within the 14-day period and outside the 14-day period. And if
there's no accrual of the right to serve the further notice, and it's the further notice that's referred back to.
Exactly. I mean, it's a matter. It strikes me as being absolutely blindly obvious that the ending of the default in 8.4.3 has to be after the 14 days have expired, because if it says it's referring to the possibility that the employer does not give the further notice referred to in 8.4.2 ... as a result of the ending of any specified default. Now he couldn't possibly not give the notice as a result of the ending. Well, I suppose it's a matter of impression. But all I'll say is that I'm not, at the moment, my impression is not the one that is common to the parties.
And common to the Court of Appeal at page 111, paragraph 33. But they interpret it in the way that has been common to the parties.
Yes.
But in order to obtain symmetry, you can obtain symmetry by construing it in that way, the way that my Lord Regis has just suggested.
My Lord, if you did, you'd be concluding that the function of the words, if the party does not give the further notice referred to means that they have to have had the right,
Yes.
which is really the point on the appeal. In my respectful submission, it doesn't mean that on its plain and natural, on the plain and natural meaning of the words. What one has here are two rights. You have a right to terminate for continued specified default and a right to terminate for repeated specified default, two different mischiefs. And there's no reason in principle as to why you would have to have had the right to terminate for continued specified default to gain the right to terminate for a different type of breach. The words that were used...
I mean, it just, to me, the suggestion that the employer could then serve a further notice on a minor transgression of the regulations, for instance, in circumstances where the employer is contending that they couldn't, the contractor cannot end the contract for a minor default in payment.
But, my lord, these are defaults that the parties have chosen within their contract to give a certain status. It's not every breach of contract that gives rise to these rights. The parties have chosen these as the particularly significant breaches that might come to be specified defaults and that might therefore, in principle, in one of two ways, give rise to a right to terminate the contract. And secondly, as I've submitted in my written case throughout, that is exactly how the form worked before. The 1998 form unequivocally, and nobody disputes this, operated in that way. If the industry, which you might think is the best arbiter as to what's commercially acceptable or sensible and what's not, happily contracted on that basis for a number of years, and there are comments in the authorities on the form as to why it works that way, the purpose behind it, and that this is how it's understood to work. There should be no squeamishness about holding that the slightly revised form of wording has exactly the same effect. My lords, can I make what I proposed to do, or had proposed to do, is make some points about clause 8.9, make some points about clause 8.4. I think I've made the points that I'd wish to make about the previous version of the form and the guidance, and then say something about purpose, commerciality, and consequences. And so focusing on 894, if the court has before it page 351 of the bundle, my lords, the point that I made a moment ago, I'll come back to it in the context of consequences.
On 391 here, are we?
351, please, my lord, which is...
It's in your case. Or
yes, sorry.
This is within the...
yes, 8.9.
Clause 8.9. That
I think you said 8.4.
You did.
Yes.
Did I? I'm so sorry.
Yeah.
So there are, within this, question one that the court has to ask is, what is the mischief being addressed? And it should be uncontroversial that there are two distinct types of mischief at play here. A continued failure, falling within here 8.9.1 that has been specified, or a repeated failure. There are two termination rights as remedies that respond, we say, to those two distinct situations. Now, it's common ground, my lords, that in the case of termination for continued specified default under 893, subject always to the proviso in 8.2.1, that if the employer ends the default 1 day over the permitted period, 28 days here or 14 in the standard form, the contractor can terminate immediately. There's no need for, there has to be a termination notice, but there's no need to specify anything else. So if the employer strays 1 day over here, the 28-day period, then the contractor can terminate immediately for continued specified default. It's also common ground when one looks at 894 that the employer need only repeat the default once to engage the right to terminate under 894. So a single repetition is enough. And one might say, well, is that realistic? Is that acceptable? But that's what the parties have chosen. Everybody agrees that. You only have to repeat it once to give rise to the right to terminate. So in each case, and whichever party's case you take, there are some precisely drawn parameters that trigger a potential right to determine, subject to the proviso, that could, in each direction, operate in a way that the court may consider to be harsh. But it is subject to the proviso, and it is what the parties have agreed, whichever way one looks at these provisions. There is that proviso at 8.2.1, notice of termination not to be given unreasonably or vexatiously. And we respectfully submit, and will come on to submit, that it would be odd to add a proviso to the contractor's right, and at least on the appellant's case, only the contractor's right, to terminate for the mischief of repeated specified default, that the contractor must have previously had the right to terminate for continued specified default. Why would one choose that proviso if one was really concerned with unreasonableness, and you've taken that head on by the well-worn proviso in 8.2.1 that termination notices aren't to be given unreasonably? Now, as to the key words, my lords, if the contractor for any reason does not give the further notice, it is those words that stipulate, according to the appellant, that the contractor must have had previously the right to terminate under clause 8.9.3. And indeed, on the appellant's case, without those words, clause 8.9.4 would unambiguously mean that the contractor could terminate immediately upon repetition of a specified default, whether or not it had had the right to terminate for continued specified default under 893. So the appellant's case is that in order to stipulate that you only get the right to terminate under 894, if you have previously had the right under 893, the draftsman added the words, if the contractor for any reason does not give the further notice. And I respectfully submit that those words simply don't bear that meaning. And that if the draftsman had wanted to impose such a precondition upon the right to terminate under 894, those words would be a remarkably inappropriate choice to have made. And I'll come back to that in responding to the redundancy point in a moment, if I may. In terms of the formulation, what's been described below as the conditional words, if the contractor does not give the further notice, we respectfully submit that those words mean what they say, that they describe, as I've submitted before, a factual state of affairs. Was the notice given, or was it not, adopting their plain, ordinary, natural meaning? Now, the appellant says that these words import the concept of taking an active step, and this morning the appellant has urged upon you more than once that they import the concept of choice into the exercise. So you have the right and you choose to exercise this or you don't. But with respect, we think that cannot be right. And test it this way. If the notice was not given, suppose the right had accrued, but the notice was not given due to inadvertence or accident, it would be an odd result indeed if in those circumstances the right under 894 didn't arise. And yet that is the consequence of importing the concept of choice into the words.
Well, it would normally be a question of choice. I mean, of course, it could be as a result of inadvertence, but normally, surely, it would be a matter of choice.
I would expect, my lord, with no evidence, just as a matter of common sense,
exactly,
that more often it would be a matter of choice than it would be something else.
Yeah.
But it would be wrong, in my respectful submission, to rule out all of those other factors.
I don't think they are being ruled out. I mean, I think it's being said that if after the 28 days the notice isn't given, for whatever reason, inadvertence, choice or whatever, then the right under 4 arises.
Mm. It's the way in which that case is made, which is to say, well, the language that is used here, you get to that result.
Well,
because the
I think the draftsman can assume that, drafter can assume that normally it will be a matter of choice.
But
it doesn't rule it out its application if it happens to have been inadvertence.
Mm. Well, Lord, I respectfully agree that it would be a very odd result if inadvertence. But insofar as the court were leading towards a construction that meant that you had to have the right because the language that has been used is more consistent with choice, well, that's, in my respectful submission, not a secure foundation. Secondly, and my lords, we've touched on this more than a little bit already, but the formulation that's adopted in 843 for the employer right is said by the appellant to mean that that those words don't mean that the party had to have had the right. Now, as to for any reason, my lords, to find for the appellant on the appeal, you'd have to conclude that for any reason didn't mean that, and you would have to read a qualification into those words which fundamentally changed the contractor's rights. Contractors, my lord, need to be able to understand how these provisions work. And
only a lawyer could possibly interpret it the way it's being argued it should be interpreted. Nobody in the street would ever imagine that the words, if for any reason you don't serve the notice under 8.3, could apply in circumstances where a right to serve a notice had never arisen. It's a clever argument that would occur to a clever lawyer.
My lord, might be flattered by being described as but equally, in my submission, if a contractor is seeking to exercise his right to terminate the contract, a step of that significance, he is going to take, in many cases, legal advice, but he's also going to look very carefully at how the provision was drafted and ask himself the question, what do these words mean? What right does this give me? And he's going to read the words if the contractor, for any reason, does not give the further notice referred to, and ask himself the question, does that exclude the reason that the employer has stopped short of giving me the prior right to serve that notice? And if for any reason the contractor does not give the further notice, comprehends, it doesn't exclude, it covers the situation in which he does have a choice. But those words also, importantly, do comprehend the situation in which he hasn't accrued the right to terminate under the 893 and give the further notice.
Do you accept that the appellant's reading of those opening words is a plausible reading? I mean, of course I accept, I acknowledge that you say it's wrong, but do you say it's a plausible reading?
My lord, it's a reading, if I can answer the question this way, it's a reading that if you read the clause once and quickly, you may arrive at. But when you scrutinise the provision and you ask yourself the question, what do these words actually mean? What scenarios do they cover? And that's before you even get into the territory of looking back and saying, well, everybody in the industry well knows and understands that one could always previously terminate in these circumstances without having had the prior right. then you are inevitably drawn to the conclusion, on the plain and normal meaning of the language, that it does cover the situation in which you find yourself, where you haven't had the prior right. My Lords, in response to the proposition that those words add nothing on the respondent's case, but only add ambiguity, there are a series of points in my respectful submission that fall to be made. First of all, those words are useful in that they make clearer that a failure to give the notice under clause 8.9.3 will not prejudice a potential right to terminate under clause 8.9.4.
So you say they're for the avoidance of doubt?
That's right, my Lord.
Don't seem to have worked very well.
Well, that's in a sense, my Lord, because we're not dealing with that case. Can I explain what I mean by it? So if, as is put hypothetically, the provision read, if the employer repeats a specified default, then upon or within 28 days he can terminate. So if that was the reading which was put forward in the appellant's submissions, then there would be no problem, in a sense, if the specified default had been ended within time under 8.9.3, so that no right had ever arisen under 8.9.3. But in the circumstance whereby the employer had not ended the specified default within the here 28-day period, and so the right to terminate had accrued, someone might say, whether they be a clever lawyer or something less than that, what does it mean, the fact that you had the right to terminate for the specified default under 893, but you chose not to exercise it? Are you still entitled to rely upon that specified default in order to then gain a separate right, potentially months later, upon repetition? So it makes clear that your failure to exercise your right under 893 will not prejudice your right under 894.
That's the appellant's case.
That's my
You
submission.
said the failure to exercise your right under 8.93.
Yes. Yes.
Your case is that it applies even when you couldn't exercise your right under 8.9.
Yes, my Lord.
Sorry.
Yes.
So I thought you were... Well, what are you saying this makes clear?
This makes clear that in circumstances where you did have the right under 893,
Yes.
your failure to exercise
Yes.
that right...
Okay, that's the appellant's case.
Yes. So it makes clear that the appellant's scenario or case on 893, which is common ground, it's common ground that for 893 you have to have the right arise. This makes clear that not exercising that right will not prejudice the separate right that can arise under 894.
Sorry.
And in terms of the proposition that these words are therefore surplus, I respectfully submit that's not necessarily right. But in any event, even if the court were to conclude that these words ultimately added nothing, to just take my example, the concern of the contractor that had had the right and not exercised it, and worried that it wouldn't have the right under 894. Suppose that those would not be valid concerns, nevertheless, A, they respond to a potential scenario, and B, this is very far from a case in which an entire provision is being rendered OTOs by one of the parties' constructions. Rather, it's simply those introductory words. There's if I'm going to put it this way, it's a very important point when one's considering these words and what they add or what they don't add, given that it's common ground that without these words the respondent would be correct. one has to look at the words. And if we could have a look, please.
I mean, you say it's a clarificatory provision. You're sort of saying, are you, unless I've misunderstood, that it's a sort of without prejudice to your rights under 8.9.3. Is that right?
The failure to exercise your right under 893 won't prejudice your right if it arises under 8.
Without prejudice to the rights under 8.9.3.
Yes.
Well, it's a very odd way of saying that, isn't it?
But is that what you're saying? I thought you were saying its purpose is to say that even if you didn't have a right to give a notice under 3, you can nonetheless give this notice under 4.
That is my construction of the provisions.
Yes.
Absolutely right, my lord. What I'm doing now is tackling the proposition that the introductory words that we are concerned with, if the contractor, for any reason, does not give the further notice, take what would otherwise be a provision that has the effect for which I contend and turns it into a provision that means you have to have had the prior right.
Can I ask you something else, Mr. Channels?
Yeah.
If we're looking at the forms, the decision in this case is obviously of great importance. And I mean, looking online, the commentary on the judgments below reflects the importance. There's been quite a controversy over this. Now, the 2024 edition of the JCT form is in the same terms as the form that we're looking at, the relevant part of it. And that edition was finalised after the TCC judgment, before the Court of Appeal judgment. So can we take it the JCT committee must have been content with the decision of the TCC?
My lord, I don't think you can. My understanding is that these forms are worked up by committee over significant periods of time. On any view, the first instance decision, which was a short extempore judgment, that I don't, as a matter of fact, I'm not saying people weren't aware of it, but it didn't even appear on Bailey until the Court of Appeal decision came out. Short extempore first instance judgment. The idea that the JCT and all its constituent parts would have hastily amended a provision that had been in this form for 20 years in response to that, rather than remaining content to see what happened thereafter.
Yes, you may well be right.
So, most respectfully, we simply can't take that. And if the JCT had felt strongly about it, then one might think they'd have accepted the court's invitation to intervene and make that clear. The passage to which I'll be grateful to direct your attention, you'll find in the bundle at page 1499. This is a passage in Lewison, and just picking it up, please. Towards the bottom of the page, there's a citation from Lord Leggett in Gem Management and Firefox, which he says it's not uncommon, however, for commercial agreements to adopt
Sorry, this is page, what did you say?
1499, my lord.
Oh, sorry, I got the wrong page.
It's not uncommon for commercial agreements to adopt a belt and braces approach that seeks to protect a party against every possible risk by addressing possibilities that do not realistically exist. Then he goes on, and then if we carry on with the passage, there's then an extract from the judgment of Lord Neuberger in Lehman number 4, which you'll find set out over the page at 1500. The fact that an expression in a sentence, especially in a very full document, does not, on analysis, have much, if any, effect, if it is given its natural meaning, is not, at least on its own, a very attractive or very convincing reason for giving it an unnatural meaning. The argument for redundancy is seldom an entirely secure one. Even in legal documents, or some might say especially in legal documents, people often use superfluous words. And then this, And if one has to choose between giving a phrase little meaning or an unnatural meaning, then in the absence of a good reason to the contrary, the former option appears to me to be preferable. Then the learned editor goes on, even where the presumption is of some value, an argument based on surplusage cannot justify the attribution of a meaning that the contract interpreted as a whole cannot bear. And we respectfully submit that if you were to conclude that the words were strictly surplus to requirements, the choice here is between giving them their natural and ordinary meaning and accepting that. In other words, if for any reason the contractor does not give means exactly that, or finding that if the contractor for any reason does not give the further notice, in fact means if the contractor for any reason, save that he had no right to give it, does not give the further notice, which, as I've submitted before and I maintain the submission, involves a fundamental rewriting of the provision. My Lords, on 8.4, you have the essence of my case. Can I summarise it briefly in this way? If you accept, as the Court of Appeal considered, and as the appellant and the respondent say on this appeal, that the effect of clause 8.4.3 is that one does not have to have had the prior right under 8.4.2 to be able to terminate under 8.4.3, then you are concerned then with comparing the very small differences in wording between those two provisions, as well as the background that is provided by the guides to these forms, which make clear that the rights work in the same way for both parties. And as to the differences in wording, the use of for any reason, which was introduced in the 2005 form, it didn't used to be there in the 1998 form, the introduction of those words set against the use of the words, whether as a result of the ending of any specified default or otherwise, would or should inevitably lead to the conclusion that these provisions work in the same way, and that for any reason comprehends as a result of the ending of any specified default.
But why were different words used? The 1998 version, the provisions for the contractor terminating and the employer terminating pretty closely tracked themselves. So the drafter decided to discard all that and to use new language. I just can't understand why he used or she used different language in the two provisions we're looking at here, unless a difference in meaning was intended.
Well, my Lord, in answer to that, there are 2 points, fundamentally. On the one hand, one has the question of an inference being drawn from the use of different phrases. Set against that, one has, on the one hand, comparison between the different phrases, and asking yourself the question, well, they are different words, but do they mean the same thing?
Why? I know, but why are we put in that position if the drafter intended to have the same meaning?
Well, in terms of what the draftsman intended, he made that pellucidly clear in my submission in the guide that he published.
But the place to make it pellucidly clear is in the contract, not the guide. What is your explanation for there being different language? What's your submission as to why different language appears?
Well, my Lord, having used the slightly fuller expression in 8.4.3, in the context of which one would inevitably read 8.9.4, the use of the form for any reason, my submission must have appealed to the draftsman as a form of words that obviously covered the fuller expression in 843. Beyond that, I can't help. It would be
you say it's just an abbreviation. You say it's just an abbreviation.
Yes, in essence.
And even if we're looking at the intention of the draftsman, we're looking at his objectively ascertained intention from the words used. The guide has a great big disclaimer on the very first page saying this is just a general guide and it's not a substitute for getting legal advice. At least I think they all say that. It strikes me as an invitation to substitute objective ascertainment of intention with subjective ascertainment if one then plunges off in to see if he said something slightly different in the guide. Because if he has, A, he probably hasn't written the guide, but B, even if he did write the guide, he wrote it under that caveat that actually what it means is a matter for legal advice and not just to be picked up from this document.
My Lord, the point about the guide is not that it sheds a light on the subjective intention of the draftsman. In my submission, this exercise of contractual construction was concerned with the parties' objectively ascertained intentions, and one is concerned, as part of that, with taking into account as part of the background the material that was reasonably available to them. But the guides that the JCT publishes to accompany their forms are part of that. They're not decisive, but they're a part of that in my submission. So just to be absolutely clear, I'm not picking at what the draftsman at the JCT subjectively intended here. I'm making a submission about what one would take from the material in the round.
I'm a bit bothered about the idea that parties to a contract that one can construe their contract in the light of material that was available to them. I entirely see that to give the example that Lord Justice Moore-Bigg gave, if there has been some notorious change which everybody in industry will be aware of, then clearly that's the relevant part of the background. But I wonder if one can properly take into account material where there is no evidence that any party actually was aware of it, let alone read it.
My Lord, one might test it this way. I mean, it's uncontroversial to say that the state of the law, as it stands, is part of the background against which a contract falls to be construed. But no one's ever interested in evidence as to whether the parties themselves were aware, as a matter of fact, of whatever esoteric point of law might be an issue. And as to the guides themselves, one might draw a line between, for example, tracing back through the annals of time on the one hand and the guide that sits in front of them on the table. But there we are.
Are there any authorities on the use of guides to the construction of a standard form contract, do you know?
Well, there are various authorities on the use of guides. There are notes of caution in respect of not straying to subjective, or the guides potentially straying too close to subjective intention, but the general approach, if I can characterise it in that way, is to treat the guides as an admissible aid. And so, for example, in the decision of Mr. Justice Hildyard that you have in the bundle, I'll just give you the reference, if I may. At page 1083. 1083.
Thank you.
This is one of the Lehman cases. And this is the decision that was cited by the Chancellor in Louisa.
Right.
There, for example, at paragraph 28, at page 1091 of the bundle, His Lordship says, ISDA published user guides to the 1992 form and the 2002 form. These contain explanations for and guidance on the operation of much of the content of the relevant ISDA master agreements and are, in my view, both an admissible and useful tool in the interpretation of the agreements. There are lots more cases than that, but they are routinely used in my submission in the case of standard forms. My Lords, before leaving 8.4, just make this point. In my submission, the language simply doesn't sustain the proposition that the two provisions operate differently. Therefore, the reasons as to why you might say parties might make that choice are, in a sense, by the by. But we say, for the reasons given, for example, in paragraphs 70 to 73 of our written case, that here it is wrong to draw a distinction between the defaults that might be specified by the employer on the one hand and those that might be specified by the contractor on the other. The court will note, of course, that there is material overlap between the provisions that appear in 8.4.1 and 8.9.1. So it would be odd to treat the parties' breaches of those same obligations fundamentally differently. It is also wrong to characterise the contractor obligations that might be specified as inherently more serious or less likely to provoke dispute. Take, for example, the failure to proceed regularly and diligently. And then there's the point about the all of the guides. And my Lords, in the time that I have left, can I say something about purpose, commerciality and consequences? I've got 5 sorts of points to make. First of all, as to purpose. Second, there is the 1998 form. Third, the comments in the cases on the 98 form. Fourth, checks and balances and the proviso. And fifth, the sword of Damocles and cash flow. Well, as to purpose, it's common ground that part of the purpose of these provisions is to incentivise compliance. And we say that's better served by Providence's construction for reasons that I will come on to. What is slightly curious about the appellant's case with respect is that it doesn't lay emphasis upon the purpose of clause 8.9 as permitting the contractor to extricate itself from the relationship by terminating its employment. Rather, the focus is on questions of equivalence to repudiatory breach or opportunities to cure, neither of which are sustainable or, in my submission, take the court anywhere. In terms of the right to extricate itself, in respect of continued specified default, which is one mischief, it makes obvious sense that there should be a defined period by reference to which the right may arise, whether it's 14 days or 28 days after the giving of notice, because you need a start date and an end date. In respect of repeated specified default, it's common ground that the right arises immediately upon repetition, and it's not obviously inherently linked to the length of any default. So the question is, do you interpret the contract such that there is a condition to the right to the remedy arising, that you previously had to have a right to terminate for a different breach, but that you didn't exercise? And I respectfully submit that approaching the question purposefully, there is no obvious reason why you should. The purpose of 894, just as it is for 843, on the other hand, is to respond to a situation where the employer is in repeated default and to impose a condition that the employer has to have previously been guilty of continued specified default so that a right to terminate on that ground also had arisen. A, has no clear logic, and B, significantly weakens the availability of the remedy of termination for repeated specified default. And linking that to the commercial consequences, on the appellant's case, the employer could be very late in paying what was due on as many occasions as it pleased. It's not always a question of choice. Sometimes it's a question of negligence or recklessness. But that there are commercial reasons why employers don't pay until they absolutely have to. They could be late on each and every occasion, but provided that no single default exceeded the period of 14 or 28 days after service of the notice, then no right to terminate under the contract would arise. And that, we respectfully submit, represents a very substantial hollowing out of the remedy for what is to the contractor a very serious pattern of default. Now, you were told that in many cases, in this case, late payment was corrected, or payment was made on time, and in others it was corrected promptly. But it is common ground, as you have seen from the statement of facts, that in 19 of the 33 payment cycles, the payments were made after the final date for payment. It's very important from the contractor's perspective to remind the court how this works and what the consequence of a decision in the appellant's favour would be. So work is carried out, and so cost is being incurred. Monthly, the contractor makes interim payment applications by the interim valuation date. For your notes, that's clause 4.7.3 at page 270. 7 days thereafter is the monthly due date. So the due date is 7 days thereafter. 4.7.2, page 161. 21 days thereafter, or 14 in the standard form, is the final date for payment. But you don't have to wait until that point.
Don't have to, but...
Have to. Precisely. Precisely, my lord. So to obtain the right to terminate for continued specified default under 893, you have to then serve your notice of specified default and then add 28 days, or 14 in the standard form. So for the right to arise, you're talking about a period after the due date of 50 days in this contract, or in the standard form, 29 days. So a month to a month and a half. This is in the context of contractors likely working on very fine margins. They have to pay their suppliers, staff, subcontractors, VAT. My lords, you'll see in my written case at paragraphs 87 to 88 an introduction to some of the potential consequences of a pattern of default like this. But if the employer can pay up to 1 to 1.5 months after the due date every month, then the right to terminate for repeated specified default is pretty worthless. The remedy is A, no meaningful incentive to compliance, and B, simply doesn't respond on that basis to the mischief, which is repetitive payment after the final date for payment, periods that can be, on any view, substantial. You'll get a sense of that in the Rainwood and Brown and Ferrara Key cases that were cited below on the previous version of the form. And it's important to have in mind, my lords, that there is no other remedy, targeted at repeated default. The other remedies suggested by the appellant are either not remedies at all, for example, the right to a stage payment under Section 111 of the Act, or they're remedies that relate to individual late payments of a certain degree. And if one takes, for example, the availability of suspension as a statutory right in response to a late payment, it is, with respect, hard to think of a more chaotic and worse way of responding to a pattern of repetitive late payment than repeatedly suspending works on site in the hope that ultimately you could make good your losses by exercising your contractual rights and recovering under the dispute resolution provisions. You'll see my submissions on this topic at paragraph 91 of my written case.
How does repudiatory breach work, do you submit? We've got continual late payment. How do you think that would work?
Well, my lord, I have to be a little careful because it's a live issue in this case.
Right.
But here we have 19 out of 33 payments made late. That the appellant was in repudiatory breach is hotly contested. And indeed, in the appellant's case, they have set out propositions to the effect that late payment will typically not give rise to a repudiatory breach. You have, for example, in the bundle, the Dalkaya and Celtec case, in which Mr. Justice Christopher Clark looked at some of the law on late payment. Doesn't go as far as to deal with how the law would respond to repetitive late payment, but in circumstances whereby timely payment might not typically be taken to be of the essence of the contract, one can see that there are going to be some serious arguments to be had at that stage.
Can you just give me the page reference for that authority? You say it's in the bundle.
Yes, it's in the bundle, my lord. It's Dalkaya and Celtec, and the case itself is at, forgive me.
Well, if you can't immediately find it, it's okay.
No, I can do a bit better than just give you the case. I can give you the paragraph, if my lord will indulge me for a moment. So it's the case itself is at page 700.
Yes, thank you.
And the section on repudiation starts at page 751 at paragraph 129.
Thank you very much.
And at paragraph 130, as Lordship says, stipulations as to the time of payment are generally not of the essence of a contract of sale or hire or other similar commercial contracts unless a different intention appears from the terms of the contract. So the idea that, well, none of this matters because the respondent can rely upon a right to terminate at common law is in my submission, not realistic.
It matters enormously because it has the effect that following one breach, the employer has a sword of Damocles hanging over him for the remainder of the contract.
Which as explained in the earlier authorities, is a powerful, and in my submission, extremely important incentive to compliance.
Of course.
But moreover, and importantly, it's not difficult to pay on time. The periods involved, as we've seen, are substantial. What the parties have done here is to weigh up the interests of the two sides of the industry. They've identified timely payment as a critical obligation, and if the employer was interested in avoiding breaking through the thin ice, it's very easy for him to do so.
Now, we're past 1 o'clock, Mr. Channels, so I'm afraid you're going to have to come to a close. Well, we're grateful to all counsel for their assistance. We'll take time now to consider the arguments. It's a short point, but a very important one. We'll let you have our judgment as soon as we can.